Cheers, everybody. I hope you all have a drink. I want to thank you for being here. Today we crowd your calendars, we destroy your marriages, we make you bad parents because everybody wants to come here all the time to the Humanities Center. We make our colleagues neglect their work, their preparation, but we thank you very much for always being with us here at the Humanities Center. As I never fail to say, without your presence, no spectacular speaker would actually accept our invitation. Nothing would happen short of your being here with us. Thank you. Master classes are the Mahindra Center's attempts to showcase scholars engaged in one of the humanities' essential practices, interpreting with scrupulous care and patience a single text or image. Over the past few years, this series has been capacious in its particularities. We've looked closely at a Yeats poem and at Auden's poem about Yeats, paintings by Caravaggio and François Boucher, a shot from Bonnie and Clyde, a little-known satire by Bentham, and John Coltrane's A Love Supreme. All of these have been part of our masterclass series. No doubt these masterclasses provide instruction and edification, but beyond their pedagogical aims, they allow for the pleasures of a slow and serious working away at textual and visual details. Building a picture of the humanities by emphasizing the importance of the defining detail, the single work, or the individual experience, does not amount to a narrowly subjective reading that isolates the text in hand. It allows, I believe, for a free play of the imagination and intelligence, less fettered by disciplinary regulation or pedagogical protocols. The one-to-one response allows for an interdisciplinary errancy, a willful wandering that enables the interpreter to move easily across the frontiers of conventional classification, whether it's genre or mode or discipline. Our emphasis in these masterclasses on the virtues of slow reading as unraveling meanings and discovering new frames of reference, with the speaker interacting with the audience at the same time, this ongoing shared communicational process, this generosity of giving of ideas and receiving them, I believe follows Kant's dictum on public reason in his wonderful essay, What is the Enlightenment? A public can only achieve enlightenment slowly, Kant writes, disseminating the spirit of rational respect for personal value and for the duty of all men and women to think for themselves. The back and forth of open-ended conversations, the ongoing revision of critical dialogues, remembering, repeating, and working through, interpretation, intervention, and the entangled practices of doubt and deliberation. These are what our masterclasses aim to do. These are the kinds of conversations we aim to have. Public reason, as manifest in our classes, is not only a cognitive or philosophical category. It is a mode of public education and communication, essential to the success of civil society, as witnessed by one person confronting one work of considerable and controversial importance. My Kantian plea for slow reading will now be entirely disregarded by my friend and colleague, Noah Feldman. His remarkable speed of thinking and speaking often results for the rest of us in severe cases of whiplash as we try and keep up with the ins and outs of his dazzling performances. Speak slowly. Think a little slowly, Noah. Noah, who wrote the definitive account of Franklin Roosevelt's attempt to pack the Supreme Court with pro-New Dealers, has generously agreed to join us tonight to engage in unpacking rather than packing. His text is Oliver Wendell Holmes's 1927 opinion in Buck versus Bell, upholding Virginia's compulsory sterilization statute with its notorious culminating statement, 3 generations of imbeciles are enough. Noah Feldman is Bemis Professor of Law at Harvard. His most recent books are Cool War, The Future of Global Competition, and Scorpions, The Battles and Triumphs of FDR's Great Justices. I won't enumerate his many awards, honors, and accomplishment, except to say that in 2003 he served as senior constitutional advisor to the Coalition Professional Authority in Iraq and advised members of the Iraqi Governing Council on the drafting of the interim constitution. He has the unique distinction of appearing twice on the Colbert Report. Noah, welcome. Please raise your glasses to Noah Feldman.
Thank you very, very much, Homi. I'm grateful to you and to Steve and to Sarah for putting this together, and to all of you for coming out on what would otherwise be a beautiful evening to talk about eugenics. Let's start with the facts of the case, as is conventional in a certain genre of legal conversation. So you all have the reading, which is reduced to a single page here. I've edited out exactly one paragraph, which I'll refer to later. Believe me, it's not an interesting paragraph. So what you have in front of you is the document that we're going to engage with, though I hope we'll also try to get behind it. There are microphones. Someone will tell me where those microphones are. That will be very helpful. Excellent. May I ask for a volunteer to tell us the facts of the case and commence our conversation? It's always difficult to get the very first person to volunteer, but believe me, it gets much easier after that. Would you agree? In the orange sweater? Yes? Thank you very much. You seemed very enthusiastic about that. Please, and tell me your name.
Philip, nice to meet you.
Philip, thank you, Philip. Thank you very much. So let's try to focus on the facts rather than the law at this point. What did you take to be the facts of this case from the text as you had in front of you?
There is a young woman, or young female, of arguably feeble mind, who had been sterilized based on...
Not quite yet.
Not quite yet, in this case.
She will be, but she hasn't been yet, yeah.
Okay. Then she's considered... they are considering to sterilize her based on an act of Virginia and a rather broad interpretation of a law that should benefit the society in general.
Excellent. So the young woman's name is Carrie Buck. What else do we know about her? How is she described in that initial moment? I think it's not a coincidence. The description is not a coincidence. Philip, you could answer that, or someone else could, but that's even better. Go ahead. Joseph?
Right. It was claimed that her mother was a so-called imbecile, that she was also an imbecile, and that she had been wantonly produced an offspring already, and that they interpreted her not only as an imbecile but also as promiscuous. And so it was in relationship to the fact that she had already had a child that this procedure was suggested.
Yes, exactly. So just as Joseph says, the text says, and this is the beginning of the second paragraph, the second sentence, she is the daughter of a feeble-minded mother in the same institution and the mother of an illegitimate feeble-minded child. These terms were technical, though imprecise, if it's possible to say that. In fact, nobody in the courts below had said that she was an imbecile, which was itself a category lower than moron. That's Holmes's rhetorical flourish, which we'll come to. But she was legally adjudged to be feeble-minded, and the claim was that her mother, who was in the same institution in which she was also feeble-minded, and that her child, who was just 9 months old at the time of the trial, was also feeble-minded. Did anybody happen to notice the name of the institution in which she was held? It's a name so shocking that you can't quite believe. Yeah, thanks, Philip. So I'll repeat it for the cameras. The State Colony for Epileptics and Feeble-Minded. There was a lot of work that went into coming up with the terminology of feeble-mindedness, and it was controversial even when it was initially formulated. But it was meant to be measured by a range of markers, including IQ tests. Now, it's not in the case, but I'll just tell you, in order to make our lives as difficult as they possibly can be, that the historians who spent the most time on the facts of this case have shown that not only was Carrie Buck herself not significantly developmentally disabled by our standards, she continued to write pretty cogent letters, which one can read in the literature, to people all of her life. She had gotten through 6th grade without much difficulty, not with high scores, but she had been promoted each year. But her mother, who was also in the colony, also corresponded in a regularized way and seems to have been not, even by the standards of the time, feeble-minded. And as for the 9-month-old child, the only testimony at the hearing suggesting that she was feeble-minded was that of a social worker who initially, in a deposition, said that the child seemed normal to her, but on reconsideration said, and I quote, "There's something not quite right." And when she was asked on cross-examination, what is that thing, she said, "I don't know, but there's something not quite right." That child, whose name was Vivian, was adopted, in fact, by the same family who had been the foster parents to Carrie Buck. She was raised in foster care because her mother had been consigned to the Virginia colony for epileptics and feeble-minded. Her daughter was then adopted by the same people who had her in foster care, and whose nephew had gotten her pregnant in the first place, by her account, coercively. The child only lived to the age of 9, but when she was 8 years old and in 2nd grade, she was an honor roll student at the local school in Charlottesville, Virginia. So we're going to try to now note, however, that none of these things is in the case. So the next question we'd ask is why? Why aren't all these facts in the case? They should be, surely, and they pretty clearly are not. There is some attempt by Justice Holmes to address the absence of facts from the case, sort of buried in the 3rd paragraph. Did anyone happen to notice it? Happy to give you a hint if you'd like. It's in the sentence that begins, "in view of." In view of the general declarations of the legislature and the specific findings of the court, obviously we cannot say as matter of law, there's a missing indefinite article there, as a matter of law, that the grounds do not exist. We're not even getting to the end of that sentence, which is itself remarkable. But what does that mean? If we parse that, what does it come out to mean? Please. Here, we'll pass the microphone, just so I should add, the microphone is not so that we can hear one another, it's so that people who are watching on simulcast can hear what we're saying.
Okay. We don't have any real evidence.
But if he doesn't have any evidence, why does he accept the evidence that's before him?
It encourages him in his thinking that imbeciles exist and they should be sterilized.
Well, I completely buy that as an account of motivation. But Holmes doesn't say that. I mean, this is Justice Holmes, this is Justice Oliver Wendell Holmes Jr., widely considered to be the greatest justice ever to have sat on the Supreme Court, appointed to the court by this fellow. If we were In the law school, it would be Holmes's picture that would be somewhere around. We have 3 or 4, each copy is worse than the next, of a pretty good original. So it's not, it's not somebody who was, and he was a very self-confident fellow, as if you didn't know that already, you know it after reading this page. So he doesn't say, well, I really think she ought to be sterilized, so I'm not going to look too carefully at the facts. He has a justification that's embedded in that sentence. In light of the specific findings of the court, not to mention the general declarations of the legislature, obviously, we cannot say as a matter of law that the grounds do not exist. So this is obvious, he tells us. The word obvious is doing a lot of work here. Why is it so obvious to Justice Holmes? So obvious that he has to tell us that it's obvious. Anyone? This may be a little bit of a technical point. Please. And tell us your name again.
My name's Chris.
Thanks, Chris.
So I took him to be saying that because the prior decision had been challenged on the basis of law, he doesn't actually need to look at whether or not the facts existed that could justify that law. He only needs to ask whether, in theory, such a law would be permitted under the 14th Amendment.
Excellent. Excellent. Everyone follow Chris's answer? The key word here is, in light of the specific findings of the court, we cannot say as a matter of law that the grounds do not exist. So the distinction, as Chris points out, is that a court has already considered these facts. And in fact, in the paragraph which I omitted, just to get it all onto a single page, there's a detailing of the procedures that the Virginia statute requires before a man or woman could be forcibly sterilized. And the procedures are these. First, the head of the asylum, and in Virginia it was only the Virginia colony, makes a recommendation to a board of nominally independent experts. Then the people who are on that board recommend, and at that moment of recommendation, there's a hearing in front of that board, and the person whose body is in question is entitled to appear at the hearing. She's not automatically guaranteed a lawyer, but in this case, a lawyer was provided for her. And then, if that board decides that she qualifies under the meaning of the statute as a person who's feeble-minded, and if you look up at the statute, you'll see exactly what the requirements of the statute are. If it is the opinion that it is for the best interest of the patients and of society that the person be sexually sterilized, so if that judgment has been reached, the game is not over. Then he or she gets an automatic appeal to a Virginia state court. And in this case, it was the Circuit Court of Amherst County, which is the county including Lynchburg, Virginia, which is where the Virginia colony was located. Of interest to me personally because it's where my father was born, but Lynchburg, Virginia is famous for many other things as well, some of which may come to mind. And that court would enter an independent judgment on the same question that was before the original advisory board. Now, once that legal decision has been reached, the person could make yet a further appeal, this time to the state Supreme Court of Virginia. Again, in both of those hearings, in this case, there was no automatic entitlement to a lawyer, but a lawyer was provided to Carrie Buck, who brought her case all the way to the state Supreme Court, which held against her. Now, Chris said that Justice Holmes believes he doesn't have to reconsider the facts because they've already been decided by a lower court, and the challenge was brought as a matter of law, not as a matter of fact. And that is 99.9% right. The only 0.01% is that it's not just that Holmes thinks he doesn't have to engage in that inquiry, but rather, Chris, what do you think? And if not, then Moshe can answer.
Because he's on an appellate court, he's supposed to be reviewing the law.
He's not supposed to. Can you make it even a little stronger? He can't.
He can't exercise review over the facts.
He's not entitled to review the facts, which have been determined by a properly constituted fact finder. And under U.S. constitutional doctrine, and the Constitution actually says this about the Supreme Court with respect to the appellate courts with respect to the federal courts, and we could extend it to the state courts here too, it's not even within the power of the appellate court to consider whether the facts were correctly decided here. It must look only at the question of whether the law is unconstitutional or was wrongly decided in this particular case, was incorrectly decided in this particular case. And here the claim is that the law was itself unconstitutional. So, first point I want to bring out here is that the factual background is cleared away from the form of reasoning in this document, and yet simultaneously it's inscribed in the document. This is a crucial feature of appellate decision-making in the United States, and it's a very odd feature, one worth pausing over. Again, let me just reframe it, or reformulate it again. The Supreme Court opinion as a genre always begins with a recitation of facts and purports to reach a legal conclusion restricted to those facts and declaring a principle that would have precedential weight most narrowly on these facts. So the facts are terribly, terribly important. And they're inscribed in the case by necessity. At the same time, the actual facts are removed from the story. And what we're focused on is instead this abstract formulation called the record, which can then be referred to as equally as the facts. Of course, it's not the facts in the ordinary English sense of the term fact. It's some artificial legal record, which we will then call the facts. And it's not a coincidence that we're going to call it the facts and act as though it is fact, even knowing full well that it probably isn't fact. So what's our justification for this somewhat preposterous arrangement? This is not in the opinion. Now we're stepping outside the opinion, outside the text for a moment. We'll be back to it in just a moment. What could be a justification for a system like this? Procedural? Yeah, so Homie says procedural. I'm repeating it only for the camera. It is a procedural justification, I agree. We, the court, ought to be looking at procedures and making sure they were correctly followed, not looking at the particular facts that emerged. But, I mean, what would justify that focus? I mean, I agree that we'll say we're going to focus on the procedures, but what would morally or otherwise justify such an approach where we say, we don't care if, in fact, Carrie Buck is feeble-minded. We just don't care. That's not our business. We're just going to say that it's permissible to sterilize her.
Precedent? Because there is a line here.
Here, Homie, they'll bring you the mic.
Sorry, I shouldn't
No,
be
no,
doing
it's fine.
that.
It's fine.
It's quite interesting. There is a line here which says, that the principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes. Jacobson versus Massachusetts. It's, this. Now, whether that analogy is convincing or not, I don't know. But I'm just saying.
So we will absolutely come to that sentence,
Right.
which is absolutely focused on precedent. And indeed, as you pointed out, it's the only sentence in the entire opinion that even hints there is such a thing as precedent.
Yes.
This rather famous Supreme Court opinion cites a grand total of one prior case. But when it comes to, I'm interested even in the prior question of our strange social practice of looking only at the facts as they are presented to us and willfully blinding ourselves to what might else otherwise have been going on. Please.
Well, I would see it primarily as the future use of the case as a precedent. Unless there's some particular fact pattern which is taken as a given, it could never be used as a precedent because you'd never know what fact pattern it applied to. So
Certainly
this
true.
has to do with the future more than anything, it seems to me.
So I completely agree that if we're going to reason from case to case, and we're going to choose a form of analogical reasoning, which claims to be concerned about the facts, those are two pretty big ifs. But if that's how we want to do it, we do need some facts that we'll claim were the facts. But why should they be these facts that are presented to us, knowing as we might that they might have been inaccurately or inadequately produced? And just to deepen the problem, I just want to make it still worse. It's probably been clear to you at this point that this is not a case about which it's possible to be terribly proud. Many people today consider this to be one of the handful of worst cases ever decided by the Supreme Court. I'm about to make it even worse for you. I told you that Carrie Buck had a lawyer throughout this process. She did. He was a founding member of a eugenics association, of which the head of the hospital was a member. He was handpicked by the head of the hospital to litigate the case. His cross-examination is worse than non-existent. And at the Supreme Court, he submitted a 4-page brief. The other side submitted 30 pages. So this was, in fact, a test case which was stacked against Carrie Buck. And again, one would like to believe, one of the reasons I'm bringing this up, by the way, is that much of the contemporary secondary academic literature about this case is very exercised and angry about the distortion of the facts, which one can understand. I mean, one's gorge rises at it. And yet the legal literature, for the most part, not written by historians, but by lawyers, is rather cool about the distortion of the facts. So the historians writing about this are morally enraged. First, they give you the facts, and then comes the moral outrage, which they either imply or state overtly. And that's why I'm interested in this question, or one of the reasons I'm interested in this question, of why it's okay for the Supreme Court to proceed this way. So we've heard some good functional explanations, but I'm looking for something more normative, some moral account of why it would be okay to run our system this way. And we do. The entire Supreme Court operates this way.
I think lawyers in general and Holmes in particular thought that there should be a distinction. Yes, lawyers in general and Holmes in particular believe that there should be a distinction between the things that we find interesting as humans and the record that is considered in a case, and try to sort of comb away the perhaps discriminatory or irrelevant facts and make the record something that's as distilled and pure as possible.
Tell everybody your name.
Lena Casey.
So Lena, who's one of our best students at the law school, says something pretty profound. She says Holmes and the other justices want to remove what she calls the human dimension from the case and focus on a distillation of pure facts. So you think they're refusing the human. Fair enough, Lena? Is that what you're trying to say, some version of that?
I don't know if refusing the human or acknowledging that we are going to be human and trying in this particular instance to put that aside. So yeah, I suppose that means refusing the human.
I mean, because they're saying that there are humans who ascertain these facts, and the facts themselves are messy business of actual humans, and that those are the facts that the court doesn't wish to engage with.
Well, the response to your question, the ideal response is that the facts, messy or not, that are relevant will be in the record. To answer your question, we want the record to include all of the facts that are necessary, but no more than those facts that are necessary. I think in practice, probably, maybe the justices were happy, or the lawyers were happy to have a record that didn't actually reveal or reflect all of the facts that might be relevant.
So that sounds like a different view than you initially expressed, no? I mean, are they the same view?
Yes.
So if I understand correctly, Lena, what you're saying is that they presume that all the facts are in the record. They wish all the facts would be in the record, but if they aren't, so
Then
be
great for them.
then they're happy about that.
Yes, so I think, I mean, this, I don't want to get too off track, but, you know, in a case about, like, for example, a witness identification, you as a defense might want a fact on the record to be, I as a white person am more likely to identify a black person as an assailant. That's a relevant fact that I would want to be on the record as a criminal defense attorney for a black client. But the prosecution, the judges in the case might be happy to keep that fact out of the record.
Well, I agree that there are certain facts that people might, under some conditions, prefer to suppress, but others would like to highlight those facts.
Yes.
Please, Homie, yeah, please. Let me bring the microphone.
You were asking for, within these statements, for some normative reason.
Of why we would allow
Some
such a thing.
normative and maybe institutional reason.
Yeah.
So there's a different issue there, whether
Yeah.
you suppress the facts or whether you create a certain kind of factoid or factuality.
Yes.
Using
Well, I think,
normative.
yes, I agree with that. And what I would claim is that, just not to hide my view on this, is that the fact that one chooses these artificially selected facts is an attempt to suppress messy facts.
Right.
Right. It's an attempt to make it clean and neat. Professor Kerner and then Professor Fried.
But wouldn't there, in the question of the law, have been already a place for one to have disputed the facts?
Yes.
And therefore, once having dispensed with that, the facts are kind of crystallized. But that doesn't mean that from the perspective of the law, the crystallization of those facts has to remain. In theory, one would then do a different form of appeal about how she was legally represented, rather than do the appeal which this lawyer, cards stacked against her, presented. That the way it was presented by that point so the reason for the insistence of the law is because within the broad structure of the law, there had been a place within the appellate structure for the facts to have been either come to light or the way they came to light to have been disputed.
Yes, yes. I mean, I completely agree with Joseph's institutional account. First, there was a hearing where facts were brought out. Then there was an appeal of that hearing in an actual court. Then the state Supreme Court had a glance at it. Right? And now it's coming to the Supreme Court. There have been lots of opportunities for dealing with facts, says Joseph, and as an institutional matter, that's enough. I mean, if they had known, or if someone had brought to their attention that there was a fake representation going on, Joseph says correctly, perhaps there would be some alternative avenue for bringing that claim. But no one's brought that to them, because the Supreme Court can't possibly do its job if it has to worry in every case about whether the facts brought before it are accurate. It would have to shut down. It can't do that. All it can focus on is questions of law, which is what we're going to turn to in a moment, but first, my colleague, Professor Fried.
My point is an architectural point. If you look at a hearing room, like the one in which the hearing initially took, there's probably a chair and a place for the witness in which Carrie Buck may have sat, and the deciders witnessed her and had a chance to observe her. Maybe even in the Superior Court that was so. Well, visit the courtroom, the Supreme Court courtroom. There is no witness box. There is no place for witnesses to sit. All there is room for lawyers arguing on either side. That's, if you like, the architecture of the situation.
Yes, and just to illustrate and support Charles's point, I want to just tell you a quick anecdote that I once saw in the Supreme Court. So in the Supreme Court, as Charles says, there's no room for the witnesses. Once in a while, the litigants will come to a case, but often they're not there. And there was a case which was a disabilities case, and one of the questions was whether a state had to pay for one particular extremely disabled young man who had not just a full wheelchair, but also a substantial oxygen tank with him, to whether he had to be sustained with significant assistance in the classroom. And Justice Scalia, in his engaging, entertaining, and sometimes Holmesian mode, commented from the bench, well, it's not as though he's going to die if they take him out of the chair, at which point someone sent him a note. A law clerk scribbled a note saying, he's sitting right in front of you. And it was sent up to him, and there was a kind of intake of breath in the courtroom in the moment. But the reason for this moment, which is, I think, directly relevant to this case, in fact, is that the reason I mention it is that it captures exactly Charles's architectural point and the imaginary of the appellate lawyer. In the imaginary of the appellate lawyer, the client is far away. The facts are out of the picture. Dr. Agrawal, and then if I don't get to eugenics soon, people are going to rise up and do something not good to me.
I'm a psychiatrist, so I don't know very much about the law or the facts. But what strikes me about this is that there's something more systemic under review rather than what happened or didn't happen to Carrie Buck or what the particulars of her life are. And it reminds me a little bit about being in a consulting room and listening to, presumably, the facts of a person's life. And they might retreat, the content and truth or non-truth of that content might retreat in importance for me with respect to what the mind does with those facts. So it seems like there's a different level of abstraction under review for the court in this case, and the humanity or justice of what happens to Carrie Buck seems to be a little bit less important.
I agree with that, and I think it's just worth noting that if in the therapeutic context, one of the goals of presumably both patient and therapist is to get to terms, come to some terms with the human nature of the interaction. In the courtroom, at least the appellate courtroom, the goal is to avoid the human dimension of the interaction, which is thought to be distracting from the structural inquiry, which is thought to be what we're after, and to which I think we should now turn. But Homi, you have privilege, convener's privilege.
I won't ask another question after this, but this
No,
process,
ask as many as you wish,
if
yeah.
you're speaking as fool, this
Yeah.
process is fascinating.
That's the goal.
Thank you. Well, what about, you asked for a kind of normative moment, right, which would in a way hold, not repress the facts, but somehow give you a pre-constructed distillation, institutional justification. What about this sentence? The statute then enacts that whenever the it's the final sentence of the second paragraph. The statute then enacts that whenever the superintendent of certain institutions, including the above-named state colony, shall be of opinion that it is for the best interests of the patients and of society that an inmate under his care should be sexually sterilized, he may have the operation performed upon any patient afflicted with hereditary forms of insanity, imbecility, etc., on complying with the very careful provisions by which the Act protects the patients from possible abuse. Is this not crucial to the issue you've raised?
Unquestionably it is, because it's adverting to a procedure put in place which is supposed to protect the patient. The idea is that multiple fact finders will have engaged in the process, representation will have been allowed, and most importantly, because we're now about to turn to the Constitution, due process will have been observed. Now, this did not come about by accident. The man who ran the asylum, who was also the man who drafted the law, had 2 years previously been sued for malpractice by someone whom he had sterilized without telling her or her family about it previously. He was very embarrassed by this, not to mention financially embarrassed by it, and he said, we must do something about this. I must be protected in the future. And so he lobbied the state legislature to pass the law that he drafted. And the goal of this law, and it was much better in this way, that is to say, it was much more skillfully drafted than other state laws that authorized sterilization, was to assure that a repeated process had taken place, which included the elements of notice, the opportunity to be heard, and a neutral decision maker to render the decision. By accomplishing this, the goal was to satisfy the requirement of the 14th Amendment to the Constitution, which says, in pertinent part, that no one shall be deprived by a state of life, liberty, or property without due process of law. Now, the statute was drafted to satisfy the idea that procedurally due process had been satisfied, and Holmes tells us at the very beginning of the next paragraph, the sentence after the one that Homi quoted, the attack is not upon the procedure, but upon the substantive law. So what Holmes means here is that nobody is arguing before the court that there's anything wrong with the procedure. The procedures are adequate. Okay? The 14th Amendment is satisfied with respect to the procedures. The claim, rather, the first of the two claims which we'll consider, is that under the Due Process Clause, there's still something wrong here, notwithstanding that the procedures have been followed. And Holmes frames that claim this way, he's paraphrasing. It seems to be contended that in no circumstances could such an order be justified, and it is certainly contended that the order cannot be justified upon the existing grounds. So what he means by that is that one of the claims being made to the court, one of the two core claims, is that under the meaning of the Due Process Clause, it would never be justifiable to forcibly sterilize a patient even after this sort of hearing. The state may never have that authority. I just note in passing that the word sterilize was not automatically at the time the natural or only word that would be used for the results of vasectomy or salpingectomy. Some states use the word asexualize, and the word sterilize was at the time still sufficiently closely associated with the idea of sterilizing an instrument, that is to say, avoiding the possibilities of disease, that that aspect of it ought to be noticed. Right? I just think we're paying close attention to language. We should notice that the word sterilized is not a neutral term at all. It's not even an automatic term for the procedure that was being undertaken here. So the claim, again, is that the Due Process Clause has a substantive component, not merely a procedural component, which says you must follow certain procedures before the law may carry out its will, but that there are certain substantive things, some substance of rules or laws that can never be passed by the state. It's called, you guessed it, substantive due process. Now, let's just start with a simple, basic point. I just spoke to you the words of the 14th Amendment. A person may not be deprived of life, liberty, or property except by due process of law. Do those words seem to import any notion of a substantive ban on things that might be done, at least according to their literal meaning? Show of hands. How many people think that it sounds on its face as though it's just about procedure? How many people think that it sounds as though it's about substance? Yeah, I mean, if you read the text, you have these rights. They're inalienable. They're Lockean. We know them and love them. Life, liberty, property. But we know that the state can sometimes take them away from us. It puts us in prison. It sends us off to fight in war. It takes our property in the form of taxes. It does these things. We want to make sure that they're only done with due process. Don't take them away without notice and the opportunity to be heard and a proper legislative process, all of which has been satisfied here. So Holmes is dismissive of the idea that the Due Process Clause has an extra special something in it which protects you against certain violations of your rights in all conditions, no matter that the legislature has spoken and no matter that you've had a hearing. Now, if you want to see where Holmes says this, he says it actually rather obliquely. It's in that second half of the sentence where he said, we cannot say as a matter of law these grounds do not exist, and if they exist, they justify the result. Right? They justify the result. And he has a legal argument for it as well that Homey pointed us to earlier, a citation to a case called Jacobson against Massachusetts, in which a man objected to paying a $5 fine after refusing to be vaccinated in Massachusetts, and the Supreme Court held that you could be penalized for refusing to be vaccinated. And of course, vaccination has to do with your bodily integrity, Holmes is suggesting. And if your bodily integrity can be violated by the state, or if they don't violate, you can be punished for that, you can be coerced into it, then he says, the principle that sustains that is broad enough to cover cutting the fallopian tubes, which is what happens in the salpingectomy. The tubes are both cut and partially excised. And it required an abdominal incision. In fact, very frequently people were told they were having an appendectomy when the surgery was performed. So that's Holmes's precedent-based argument for this. And his textual argument, unexpressed here, is that the words due process mean a process. They don't mean a substance. Good argument? Jacob?
I kind of want this argument to be wrong, but it seems
Good, yeah.
Holmes has made a pretty good case, even though here the result seems kind of morally abhorrent. But what if we sort of put more pressure on the word "due" and imagine that it implies a sort of proportion between the deprivation of the good things of life, liberty, and property, and the sort of justification for depriving them? That if there were the death penalty for littering, there's something undue about that. That's not what's due to you for littering. So even just that, if I were arguing with him, I would just push on that single word. That would be what I would.
That's great. That's extremely well done and very creative, and I think it gets us somewhere. You can say, well, in fact, due requires some balancing, what the European courts call proportionality analysis, where we try to figure out if the deprivation is justifiable in terms of the person's deserts, their moral deserts. And it may be the moral deserts of all humans. And then that, I think, Jacob, would put us into a question of asking the following kind of question. Does the state's interest in taking away a person's capacity to reproduce outweigh that person's interest in deciding herself whether to reproduce? That's starting to sound pretty good. Starting to sound kind of appealing. So if you don't mind giving Jacob back the microphone, who should decide that, Jacob? Let's say we're going to interpret the due process clause that way. Right? I mean, Jacob has given us a textual basis for a terribly morally appealing notion that, in fact, there must be some balancing. Legislatures can't just do what they want because they feel like doing it and a majority of people voted for it. True, we call that democracy, but farewell that. Right? The question is, what's really due to you? So, good, great question, Jacob. Who's the Platonic guardian that gets to decide?
Well, I guess it's the Supreme Court. They can. I mean, I think that I think, as a matter of fact, my sort of folk reading, naive reading of their opinions is that they do make arguments like this.
Oh, that's not only a naive reading; that's a wholly sophisticated reading. They absolutely do this today. So I will come to that in just a moment. But substantive due process, which was anathema to Holmes, was already being used in his day and is still used to this very day. So no question that it's done. But let's ignore for a moment what is done and try to figure out what justifies what is done. Who ought to do this? You say the Supreme Court. Why? Why ought the Supreme Court to be in the business of acting, and these are the words of the great Judge Learned Hand in his Holmes lectures at Harvard Law School, as a bevy of Platonic guardians? Why should the Supreme Court have that authority? Because let's just be clear what that authority is on Jacob's view. On Jacob's view, every law that is passed in the United States, be it by the Cambridge City Council, by the state legislature of Massachusetts, or by Congress, ought to be reviewed by the Supreme Court, which ought to decide whether we really need it in light of the rights that are implicated. Right? Someone ought to do that, and Jacob says it ought to be the Supreme Court. So my question is just, why? Why them? Why 9 at the time men in robes? 7 WASPs at the time, 1 Catholic, who is the only dissenting voice here, and 1 Jew.
I confess I can't, I mean, it's sort of the answer, I was sort of casting my mind to think if there's a constitutional justification. I don't know of one. Maybe you can help me out and give me an assist here.
We'll get there.
Find some constitutional textual support
Well,
for this.
there's nothing in the text for it in any direct way. The only thing you could say textually is this. The Supreme Court justices invented for themselves the job of judicial review of legislation by saying that the Constitution is a law. Our job as judges is to interpret the law. The law makes the Constitution superior to ordinary legislation. We have to find out if there's a contradiction. It's our job because we're interpreters. Of course, that still doesn't make them the final interpreters, but they slide right past that question. So that's a justification for why the Supreme Court should interpret the Constitution, and these words are in the Constitution. Right? The words due process in the Constitution. We have to know what they mean. And from the duty to interpret, we move to a supervisory responsibility over all laws that are passed anywhere in the country by Democratic majorities, because they're all passed by Democratic majorities. But we don't trust the Democratic majorities. We're going to second guess them every single time. So that would be the textual argument, to the extent there is one. It's doable, but it's not great. You don't want to rest on that. One wants a stronger case for why this ought to be done by the Supreme Court. I mean, we'll just leave it to the side now, but I want you to mull it over. Now, just as a historical matter, substantive due process was being used by the Supreme Court in this period to Holmes's chagrin, and the place in which it was innovated, in which it was primarily being used, was to protect the interests of a vulnerable minority in the United States. Anyone know what that minority was? Adam? Property owners. As we know, in the structure of democracy, the most vulnerable people are property holders. Most people don't hold property. The demos controls the state. The demos votes for the people to take the property away from the minority who have the property and redistribute it to the people who don't have the property. The Greeks knew this was a core issue in democracy. The Romans knew it was a core issue in democracy. The founding fathers knew it was a core issue in democracy. Democracy creates vulnerable minorities who are always in danger of having their rights violated. They must be protected. And their property is Exhibit A in what should be protected. If you let people take away their property, soon they'll take away their life and their liberty. Holmes was having none of it, but in this era, which is called the Lochner era, named for the Supreme Court case of Lochner against New York, in which the doctrine was most explicitly announced, the court held that the state of New York could not pass a law that limited the work week of bakers to 50 hours. Because the court said, the due process clause requires us to ask what's due. And you have a liberty to contract your own labor. It's part of your control over yourself and your body. And if you wish to work 51 hours, your liberty is infringed if you can't work those hours. So the due process clause says we have to ask whether the state's interest in regulating your hours outweighs your interest in the control over your own body and your labor. And it said, of course it doesn't. So that was the substantive due process doctrine at the moment, and Holmes was against it, thoroughly. And in fact, the best way to understand not the rhetorical flourishes of this opinion, to which we will move, but the substance of the case, and Holmes's enthusiasm about it, is not especially his love of eugenics, which was not trivial, but his desire to undercut the principle of the use of substantive due process, which he thought inverted the ordinary structure of government and was fundamentally anti-progressive. Because in this period, it was progressive legislation passed by states, like the regulation of safety in the workplace, like the regulation of hours, like the stabilization of wages, like the sterilization of the unfit, which was just another piece of the progressive agenda at the time, it's important to note, that the Supreme Court was mostly involved in blocking. So Holmes thought he was striking a blow here for a procedural theory of due process, not a substantive theory of due process. Subsequently, after, this is just to fill in the rest of the historical pictures, you'll know how we got to where we are from where we were. After World War II, after Franklin Roosevelt had packed the court, after liberals eventually managed to get themselves a majority on the court, they jettisoned the idea of substantive due process in economic matters and reinvented it in matters of bodily integrity, and developed the doctrines whereby, first, the individual right to privacy as construed with respect to the use of contraception, and then the right to abortion were derived. Subsequently, the right to gay marriage was derived from the same principle. All of these come from substantive due process. So substantive due process lives and flourishes, and it lives and flourishes no longer in the realm of economics, but now in the realm of control of one's body and reproductive and sexual functions. So that's where due process has gone and is where it is today. Not imaginable in Holmes's day, but one of the reasons that Holmes's opinion looks so bad in retrospect is that we live in a universe where substantive due process is a good thing that progressives believe in, not the fundamental enemy against which progressives are arrayed. And a cynic or a historian would say it all depends on who has 5 votes. Right? If you have 5 votes to protect the vulnerable minority of property holders, then the people who don't have property would think that substantive due process was a terrible idea. If you have 5 votes to protect abortion rights, then the people who favor abortion rights will like substantive due process. Okay? All right, so that's just a historical view of how we got there. Okay, so now let's turn to Holmes's more shocking formulation. And it starts with the sentence, "we have seen." We're still in that second to last paragraph. "We have seen more than once that the public welfare may call upon the best citizens for their lives. It would be strange if it could not call upon those who already sap the strength of the state for these lesser sacrifices, often not felt to be such by those concerned, in order to prevent our being swamped with incompetence." We'll build our way to the next couple of sentences, but let's just focus with that formulation. So what's Holmes talking about when he talks about the sacrifices demanded of the better sort? He's talking about conscription. As Moshe says, he's talking about conscription, and not just any conscription, but a particular formative experience, the formative experience in his life, the Civil War, the people who are memorialized in Memorial Hall, you know, a whole 200 yards from here, who were Holmes's friends and classmates. Holmes himself was injured first at Ball's Bluff, where he was the first Massachusetts man to be injured. He was then sent back and injured again at Chancellorsville. Then he was injured a third time at Antietam. His best friend was killed. The second time he was injured, he was so nervous when he was sent back that he brought himself a bottle of poison for the purposes of drinking it should he be injured, so he wouldn't have to experience the horrors of injury. He was injured, and he drank it down, attempting suicide. His sergeant had substituted gin. That's the only reason he lived. That's how bad he thought it was to be injured. And as our colleague Luc Menand puts it, describes very wonderfully in the opening section of his terrific book, Metaphysical Club, on Holmes's death, there was found in his closet a uniform, a Civil War uniform, and pinned to it were the words, "This is the uniform that I wore at Chancellorsville. The blood upon it is my own." So this was the definitive moment of Holmes's entire life, crucial to his formation of his subsequent identity. And he's saying, I was prepared to die. My friends, the flower of our youth, were prepared to die. Many did die. That is a sacrifice the state demanded of me as a matter of conscription. And this sacrifice of non-reproduction is quite minor. It's barely felt. It's just not that big a deal by comparison. And the price is simply one of the things that the society demands in exchange for running itself. It demands that the best and the brightest give themselves to die, and it also demands lesser sacrifices that we be not swamped by incompetence. So what do we think of this argument? Now I think is where it starts to get interesting, in my view. Just a second, that microphone will be. Thank you.
I'm also a psychiatrist. In the 20s, there were literally villages that housed psychiatric patients. Yeah, there were literally villages that housed psychiatric patients. My father was a commissioner of mental health. I'm sorry, there were huge towns of psychiatric patients. So there were hundreds of thousands of patients who did not have medication. And they were always sort of tucked away so other people did not have to see these patients. I myself trained at the Boston Psychopathic Hospital, which became the Mass Mental Health Center, that trained very famous psychiatrists. And there were patients there for 40 years when I arrived. So
as there were in the Virginia colony, yeah.
Exactly. So this was a world unto itself.
So first of all, a very costly world. Institutionalization cost a lot of money, and Holmes is talking about that.
Absolutely.
And we'll hear more about that at the end of the opinion, about the goal of sterilization being precisely to facilitate deinstitutionalization. So one of the justifications, not the only, but one of the justifications for confinement was the danger of people having sex and reproducing. And lest we be totally dismissive about that, one of the concerns was that the patients or the inmates were particularly in grave danger of being sexually abused by people on the outside, as indeed Carrie Buck had been. Right? This was one of the recurrent concerns. So Holmes is saying, at the very least, this is a very expensive proposition. It is assumed we must institutionalize as a sign of progress, because, as you well know, these institutions did not exist in the 18th century in the United States. These are a product of the middle of the 19th century and the early 20th century. These are progressive era institutions, because it's monstrous to leave people who aren't able to function to rot or starve. They must be treated and taken care of. Sure, let's keep them out of sight. There's an unattractive component to it too. But institutionalization is thought to be necessary, and if necessary, it is costly. Add to this the assumption that Holmes is making here that the conditions which would lead to institutionalization are hereditary, which is a topic which we will get to in just a moment, but let's, for the moment, just assume with Holmes that that's the case, imagine to be the case. Imagine that that were the case. So what do you think of the argument? Do you buy the argument? The best and the brightest are required to go and die, conscription. So is it asking so much for some people who will be supported by the state and be wards of the state? Is it asking so much for them to be forcibly sterilized? The operation is brief, relatively painless. They'll go on to live otherwise productive lives. Professor Strominger.
I don't see that there's any problem with the logic in the argument or why we should even be looking for a flaw in the logic of the argument. I mean, he has...
I think it's the microphones maybe. Can we make the microphones?
I don't see why we should be, I don't see any problem with the logic in the argument or why we should even be looking for a problem with the logic in the argument. It's his assumptions or his own feelings about what's important and what isn't important. In the end, it's just a judgment call, and I guess that's what the Supreme Court has to do. He has to weigh the benefit to society against the loss of rights to the individual, and he has to decide how much weight to assign those things. There's no law which tells you how much weight to assign those things. So
Andy,
he thinks you'd... Yeah.
Hold on to the mic for a second. So I hear Andy to be saying something like this. Look, I mean, he's telling us what he thinks. Holmes is telling us what he thinks. Who cares if the syllogism is sound? It's his institutional job to make the judgment for us. Right? Once we're in Jacob's world, where we have Supreme Court justices who are weighing things,
right.
We've got a political process that chooses these people. They've been chosen, right? It's their job, and we're going to do what 5 of them say. But Andy, why does it, so I hear that argument. It makes sense to me institutionally. But let me ask you, given that there's a practice for the justices to express their opinions, which is not inevitable. You could have a system where they just vote and don't express their opinions. But here, where they are expressing their opinion, at least he is, the dissenter, Justice Butler, doesn't, which shows you the practice did not require that you express your opinion. But Holmes did. Why wouldn't we want to, simply as an analytic matter, figure out if the reasoning he engaged in is logical or fallacious? Why wouldn't that be a matter of interest to us? Because we can second guess him. I mean, he's dead,
well,
right? We're going to second guess him.
He could have made a logical error, but I don't see what the logical error is.
Ah, good. So
I don't think he made a logic. Sure, that sometimes they make logical errors, but I don't see that here. I just think his values. I don't know.
Are his values good or bad? I mean, are these bad values expressed logically?
Well, I think so, but in the end, it's, you know.
But how would we know? I mean, so this is, now we're getting something that's very, very interesting, because I hear you saying, Andy, this is logical, but it's also wrong, right? It's morally wrong. It's logically consistent, but morally wrong. But so how would we know that an alternative view was morally correct? Not by logic, is your implication. We know some other way.
Yes.
And is that because you think that, I mean, Andy, is that because you think that moral judgments are a little bit more like aesthetic judgments than they are like logical judgments?
In the end, there's some, in the end, it's not, it can't be a logical, there isn't logic to answer every question.
Good, so I think it's really helpful to have this on the table, a modestly strong form of, can I call it relativism, or will that be offensive? Moral relativism. Sorry? It's okay?
That's good.
Yeah, a modestly strong form that says moral judgments are a bit like aesthetic judgments. They're in the eye of the beholder. Sure, you can give some reasons for them, but we don't really care what reasons you give. I mean, they might be interesting to the student of aesthetics.
No, we care what reasons they give. The reasons have to be logical. I mean, if he'd made a logical flaw in his argument, that would be a problem.
Okay, good.
So he made a logical argument, and then he said, I think X is more important than Y.
Okay.
And he weighed it, and
good.
I think not too many people would have weighed it the same. And of course, one has a lot of suspicions because of the facts which were not disputed.
Sure.
But we have to extract that from this discussion.
Good. Elaine, you wanted to say something. Can we get Elaine a microphone? Here.
Well, certainly Holmes's argument is becoming much more sympathetic over the course of this description. But I think that, I don't think you'll accept this, but I think if one were confronting him with his analogy with his own military service, one would have to concede that there is a very great sacrifice that he and his friends made. However, wouldn't it be the case that the soldiers would have still had within their radius of their own will, a much greater latitude of consent and dissent than she's being given. Ella Lon, who's a historian who wrote in the 1920s, chronicled the number of people who defected during the Civil War. In the final tally, the South lost because 250,000 soldiers deserted.
But Elaine, what about the Northerners? I mean,
There are many, many Northerners deserted. Many Northerners
but if
deserted.
they were caught deserting, they would be killed.
No, they weren't. They
I
weren't.
mean, as a matter of law.
as well as a matter.
And there
of
were people. I mean, Lincoln did. I mean, sometimes he suspended the sentences, but many Northerners, not many, but hundreds, were hanged for desertion.
Right.
I mean, I guess I'm not convinced that there was. I mean, you're right. There is some latitude of people pushing against the system. The system says you must make the sacrifice, and you're right. If you shirk, you might get away with it. But by the same token, Carrie Buck could have fled.
She
I mean,
could've.
that's not the kind of wiggle room. I mean, to me, the coercive character of conscription is high on the list of coercive things. No.
It's very high on the list of coercive things, but the numbers of people who deserted is huge, much, much, much larger than those who were punished for it. And
Certainly true.
yeah.
Certainly true.
And sometimes they left and came back again, and left and came back
Good.
again.
But Professor Scarry, notice, is willing, at least for the sake of our argument, to bypass the question of whether the analogy is actually logically sound. Does anyone think the analogy is not logically sound? Ben, you don't think the analogy is logically sound, do you? No. So why isn't the analogy logically sound? Can you pass Ben? Do you mind passing Ben the microphone just behind here? Thank you.
Just purely because he had this experience of the war, and but based on having that experience, he could make any argument. He could say, well, because we did this, anyone should have to make
let's
lesser
give him a little
sacrifices.
credit. I mean, let's give him a little credit. We can say historically that he probably made this argument with fervent confidence because he was in the war. But this was actually a conventional argument. He made it a little bit more stylishly than most people, but lots of people thought this. I just mean the logic. Some people are called upon to sacrifice their lives, so therefore the state should certainly be able to make the demand of sterilizing people. You think that other than, I mean, does anyone want to make an argument that this is just not a good piece of reasoning? Jackie?
I think the fallacy in his argument is this hierarchy of value to the society, which he's presupposing that there are some who are valuable quintessentially and others who are incompetent quintessentially, and he doesn't. They might be valuable in other ways. These people may be very valuable as laborers. They may be valuable as in some other ways. So he's assuming there's just one vector of value, and that the society therefore has to ration its resources to
So Jackie, can I ask you,
support one set of and what I would also just in parenthesis note is that I think the language of swamping is so interesting because Elaine says this makes him more sympathetic. I think it makes him more familiar because we have very similar arguments today about outsiders swamping, and indeed we have similar treatment in some cases about outsiders being even sterilized, like the Roma population. So it's actually a rather familiar argument, which has one, I think, scale of value for how you categorize humans.
Can I ask you, though, imagine that Holmes had left out the hierarchical nature of this argument and had reframed it as follows, and just had said, in wartime, people lose their lives coercively, and some people have to make sacrifices of being sterilized, and hadn't actually invoked the idea of hierarchy. You still wouldn't buy the argument, would you?
No, because I don't see how you could decide which people would be sterilized. It's not a valid argument. You would then say, well, let's not bother to support babies because they're not going to fight, or let's concentrate on our resources on those who can fight. Let's not bother to support elderly people. So what's his metric? That's what I don't understand.
Well, presumably it would be just as you say, a metric of capacity to contribute to the society. That's the metric that he's using. And, I presume we could have such a metric. Wouldn't be very precise, I agree, but we could make a kind of ballpark determination, couldn't we? Can I? Okay, although, just for the record, Homi, this is my procedure. I have people who raise their hands for hours, and I don't always call on them. Okay, all right. All right. Yes.
Well, we've moved on quite a while since I first raised my hand, and so I'll just briefly comment on the analogy
But
question.
that's exactly why the method is set up
that
this
you
way.
want.
So we can have a conversation collectively.
Right.
But if you must,
But you
if
want
you
to
must.
talk about the analogy question. I didn't see that the government sentenced a particular soldier to die. They told him he had to go to the battlefield, and he had to risk his life. In this case, they sentenced a particular woman to have a self-injectomy.
Well,
I don't think they're analogous for that specific reason.
I see. I see the argument, but it's subject to the following objection, namely that if you're in the unit and the senior presiding officer tells you that you're going to be in the front today, Safta, you're in the front lines today, you don't have very much appeal from that. You are personally sentenced to die. And the Civil War was certainly like that. People were put in the front lines with certain knowledge that they would die. I mean, it doesn't have to be the Civil War. This is Uriah the Hittite. This is the order that David issues. Send Uriah the Hittite to the front lines that he may die. So I do think that if you're being put in that kind of a battle on the front line, you are going to die. I mean, what I thought people were going to say, but maybe someone will still say it, was, yes, do you want to jump in?
Well, I was just thinking two things. One, that
hold on for 1 second until the mic reaches you.
So 2 points. One, that military service is something that's considered honorable. And so these people were, although being called to die, were being honored. Whereas the other, this is a mark of you being, a mark on society. And so we're going to cut off your offspring. So one honorable, one very dishonorable. And then the good that is served to society by fighting and defending is that it can continue on, conceivably, right? The state can continue on. Whereas it's this lesser good of maybe you won't cause so many problems.
So there are 2 points there. The first one, I have to say, sure, it may be honorable to die, it may be sweet and honorable to die, but, put Falstaff in that situation, and for him, honor is a mere scutcheon, right? When you're actually dying in battle, it's not so honorable, right? So I'm not sure that the honor really solves the problem. Your second point, though, hints that there may be a cost-benefit analysis involved here. And maybe the cost-benefit could help us out a little bit. I mean, remember, Jacob wanted us to engage in a cost-benefit analysis. Okay, so what's going to happen? I mean, how necessary is it that people be prepared to die in war? How necessary is that to the survival of the society? It's very necessary, right? I mean, it is the absolute form of necessity. Moshe.
We're focusing excessively on the sacrifice of war instead of at the question as to where do you draw the line at the opposite end. Why stop at the imbecile? Why not sterilize those who have a low IQ or those who have genetic diseases that are going to be expensive to treat later?
He was in favor of both of those things, yeah.
Oh, well, then.
Yeah.
So
I'll
why
look
not focus at the opposite end of the formula, which is where do you draw the line?
So that's hugely important, and the final paragraph, which we haven't yet gotten to, which is about equal protection of the laws, is expressly about that subject. So I promise we're going to come to it. Let me check the time. Yes, I can promise that we're going to come to it. But now we're still focusing on this argument that he's laying out, and I just want to push this question of necessity, right? I mean, I take it that it's necessary to fight wars sometimes, right? How necessary is it that this sterilization occur? I mean, is the assumption of necessity that's built in here, that the necessity of the sacrifice of life in war therefore justifies all other sacrifices? Does that follow? Right? If it's necessary that somebody sacrifice and that we make that person sacrifice, does it follow that all lesser sacrifices are justified regardless of how necessary they might be? I don't actually think it does follow logically. I'm less convinced than Andy is that the argument is logically sound. Right? Andy.
Well, I think that,
I want you to defend Holmes now. It's going to be good.
I do.
This is exactly how it's supposed to work. That's good.
I think that in his view, it is some kind of nightmare to be surrounded by imbeciles and incompetence. And particularly, in the very last sentence where he compares it, in the precedent where he compares getting a vaccination to cutting your fallopian tubes. I mean, it is a logical comparison because they're both things that
invasive,
you have to do to protect other people, in his view, protecting them from imbeciles.
Yep.
But that very comparison, that he would compare those two things, that you would somehow equate them, cutting a fallopian tube to having a vaccination, shows that he's just have a very skewed sense of what is important and what isn't, and how bad it is to be surrounded by imbeciles.
So you think the first argument is logical, and the second argument would also be logical if one takes on board that there's this massive negative externality of having all these imbeciles out there.
About imbeciles in the world, which he seems to. I mean, he really goes on a rant. Wouldn't it be strange if,
Isn't it? It is better for all the world if instead of waiting to execute degenerate offspring for crime or let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. He's hardly hiding the ball here.
Yes.
Right? I mean, he's laying it out pretty expressly. Right? This is what he thinks. And then comes the grand punchline, the most famous line from this case. And I will tell you that I recently became the co-author of a constitutional law casebook. It's 2,000 pages long. It includes mostly good cases that we're happy about, but some bad cases, like Plessy against Ferguson, which sustains separate but equal. It contains Dred Scott, which held that an African American couldn't be a person under the terms of the Constitution. It has exactly one footnote to Buck v. Bell that's one sentence long, but that footnote does include this quote: 3 generations of imbeciles are enough. And I just want to ask, why is he doing this? Why is Holmes actually engaged in this kind of overt rhetorical performance of the expressness of his worry? And he calls it paranoid. At the time, I think it probably is paranoid, but at the time it was a very common paranoia, and I noted earlier, associated with progressive people. Progressive people thought this, right? So if you ever ask yourself, where would we in this room have been, and I do this every time I teach a case, where would we in this room have been in 1927 on this issue? No doubt we would have had some diversity on this issue, but progressive people were in favor of this, right? Margaret Sanger, the founder of Planned Parenthood, deeply sympathetic to this program, right? I mean, this was what, bien-pensant people in Cambridge, Massachusetts thought at the time. Right? It's 8-1 on the court, and the only dissenter is Justice Butler, who's a Catholic, because just like the Catholic Church opposes birth control, the Catholic Church opposes permanent birth control through sterilization in this period. Okay, so you do have to ask yourself, where would you have been at the time? But it's over the top. This was rhetorically over the top, and this Holmes is. Let me take it even further. Holmes is having fun. This is virtuosic having fun, and he bragged about it to his friends. In his letters to Harold Lasky, he says, "I wrote a great one on this topic." And you know what Harold Lasky wrote back to him? Harold Lasky, great socialist, president of LSE, he says, right on. He's totally on board. There are too many imbeciles out there. We need fewer of those people. Okay? I mean, Holmes, he was not above shading his comments depending on who he was writing to. And you knew Lasky was the most left-wing person with whom he regularly corresponded. So he wrote to Lasky about this, not Frederick Pollock, who was more conservative. And Lasky was completely on board, as Holmes knew that he would be. Okay, so why? Why is Holmes giving us the full treatment here? I mean, this is Holmes at his most aphoristic. He expected to be quoted in the newspapers, and he was. He expected to be quoted in the casebooks, and he is. Why? Why is he doing this? And what are we to, more importantly perhaps than why, what are we to make of this? The master in his full mode of expression, expressing stuff that to us is nasty to the point of being repulsive. Joseph, yes.
Well, isn't it somehow baked into the text some idea from the start of consensus that in order for one to go to war, there has to, even though it's a very displaced form of consensus, nonetheless, there is some sense that the state is in grave danger, and therefore war needs to take place, and therefore sacrifices need to be undertaken. And in order for the analogy to stand, and for the substantive aspect of this argument to hold, there has to be a rhetoric of consensus and of a community wherein a certain form of common sense, as well as a certain form of prejudice, as well, I think, as a certain form of humor, brings together the populace in such a way that you mobilize the populace in the same way you would in relationship to, say, a war.
Although I think that's a brilliant point, but in a war, one rarely makes jokes as part of the process of rallying the troops. And he's making, as you say, this is sardonic, and we're meant to smile. We're going to see this in the equal protection section, which we're about to get to. Again, a sardonic formulation which is meant to make us smile. We smile now, and then we're humiliated that we smiled, but we're still doing it.
But it seems to me that and it's quite interesting to hinge, and so too does the analogy between an enemy outside, which creates the form of war, and an internal enemy. And in order to mobilize a notion of an internal enemy, you have to have a different form of consensus building, where humor and cruelty is more open.
I think that's fascinating, and I especially like the element of what you're arguing with respect to the creation of a sense of community. I think the community that's being created is a community between the author and the reader. And the idea is, if you're reading this, or seeing it quoted in the newspaper, there's only one thing we know about you. You're not an imbecile. You're not one of them. And there, I think humor does play a major role. It's a way of galvanizing us to exclude this other group of people. And the humor kind of inscribes our confidence in our own superiority. You know, I was talking to Dan Aaron about this case earlier, and you know, Dan was talking about the difference between a witticism, which Holmes was famous for his witticisms, and an apotheme or an epigram, which are meant to carry weight. And we were trying to figure out, which is this? 3 generations of imbeciles are enough. You know, his initial instinct was to say that it was a witticism, but I think, following Joseph, I think it may be more than that. It may be intended to be something very quotable, permanently quotable, which would then give us a feeling that we're part of a community. Now, this point is crucial for looking at the equal protection analysis. So let's turn to the equal protection analysis in the time that we have left, where the express claim being made before the court is that what's being violated is not the due process clause of the 14th Amendment, but the equal protection clause of the 14th Amendment that says that states may not deprive anybody of the equal protection of the laws. Okay? Now, if you had to argue that this statute did not treat people equally, today you would probably say that this law discriminates against people whose faculties are judged to be less advanced than those of others. That would probably be our mode of making the argument. That's not the argument that Buck's lawyer made, because there was not yet a Supreme Court doctrine saying that certain groups of people were entitled to extra special protection under the Equal Protection Clause, and that's because the text of the Equal Protection Clause doesn't say anything about protecting certain people more than others. It just says the equal protection of the laws. So either you read the text literally, in which case there's no reason to focus especially on vulnerable people, or you read the text historically to say it was about the equal protection of African Americans, and either way, you wouldn't get to the equal protection of people who were judged to be feeble-minded. So he needed some other argument, and what he said was, it fails because it is confined to the small number who are in the institutions and is not applied to the multitudes outside. In other words, you're only sterilizing people adjudged feeble-minded who are inside the institution. You're not sterilizing people who are maybe feeble-minded but are outside the institution. And therefore, you're treating two classes of persons differently based on the arbitrary fact that one group are confined and one are not. This harkens back to Moshe's point about equal protection, and therefore you violated the equal protection of the laws. Connected to this is the prohibition, is the question of whether there is a prohibition on what is called class legislation in this period. And class legislation, the word class is not precisely meant social class, but something similar. Classification, legal classification. Can a law be unconstitutional simply because it classifies people differently from other people? Okay? And Holmes has something very explicit to say in response to this, something serious, before he gets to his flippant comment. So look at the final paragraph. He says, first he says kind of disparagingly, it is the usual last resort of constitutional arguments to point out shortcomings of this sort. So rhetorically he wants us to know what you're about to hear is going to lose. Then he gives his punchline. And this is meant to be an epigram, and it's an interesting one. The answer is that law does all that is needed when it does all that it can. Now, if that sounds epigrammatic, he explains it. It indicates a policy, applies it to all within the lines, and seeks to bring within the lines all similarly situated, so far and so fast as its means allow. What does that mean? Anyone? It's hard. This is a hard legal parsing. You guys have been at this solidly for an hour and a half. You have my admiration. But one last push here. One last push. What does that mean? It's remarkably put. The law does all that is needed when it does all that it can. Indicates a policy, applies it to all within the lines, and seeks to bring within the lines all similarly situated. Jacob.
Just to give an analogy, you can't let somebody off for murder because another guy got away. The police are catching as many people as they can. You apply, and then you try to make the police as effective as possible, but that doesn't mean that escape murderers mean that.
Yeah, that's exactly it. Right? The law can't be held responsible for discriminating when it's just doing its best and fails to be fully successful in achieving that goal. A law that is under-inclusive in its enforcement is not therefore discriminatory. Okay? Sounds logical. Do we like that principle? Do we like that principle? We're going to punish crack cocaine much more strongly than we're going to punish powdered cocaine because, we're going to do our best. We're going to try to catch as many people as we can, and whoops, it seems that many of them are African American. But we're trying our best. We don't mean to discriminate. We'd like to catch everybody.
I think bringing people within the lines would have more of a powder cocaine.
Good one. But for the record, there was a joke about lines of cocaine, but since I didn't get it, I can't repeat it. Seriously, do we like this principle, that the law does all that is needed when it does all that it can? It sounds like we have to have a rule like that, as Jacob says. We can't possibly say we won't punish this murderer because we failed to punish that other murderer. But it is a very intuitively appealing principle. When laws or system are under-enforced, it does feel at a human level like an injustice to the people who happen to get caught. Right? I'm driving down the highway at 68 miles an hour with alongside everybody else. They're going 70, 71, 72. I'm stopped. I get the ticket. Right? And I was going the same speed as everybody else, maybe a little slower. But I violated the law. I feel as though I've been discriminated against, and perhaps I have been. The short answer is that the law more or less allows this principle still to this day, unless you can show very definitively some extraneous form of discrimination that causes, in a very active sense, my being singled out, the principle holds. And then Holmes gives us his cynical punchline, which is, again, here back in the sardonic mode that Joseph pointed to. Of course, so far as the operations enable those who otherwise must be kept confined to be returned to the world, and thus open the asylum to others, the equality aimed at will be more nearly reached. Right? Everyone see what he's saying? He's saying, sure, you're complaining that we haven't sterilized enough people. We'll sterilize them, we'll deinstitutionalize them, and then we'll bring in more and we'll sterilize them. Eventually, we'll sterilize everybody, which is more or less what Germany tried to do beginning approximately 6 years after this decision. And that is the point at which eugenics began to become unpopular in the United States. When the Nazi regime began doing it, you can see a spike and a decline in pro-eugenic American attitudes. By then, approximately 8,000 people, actually not by then, up until the 1970s, when the practice ended in Virginia, more than 8,000 people were sterilized in the Virginia colony. Nationwide, no one really knows the numbers. Most estimates range in the low hundreds of thousands. So I just want to close with this question of what we are to make of this artifact, this textual representation of a Supreme Court opinion, adjudged by many to be one of the worst decisions of the Supreme Court, one of which one of the justices thought to be one of the greatest justices in the history of the Supreme Court was actively proud, which has been, to some degree, shunted off from the mainstream of American constitutional law, and yet which is, formally speaking, still on the books. In Roe against Wade, the Supreme Court cited Buck v. Bell to say that the individual right to control one's own body was not an absolute right. It said, see Buck v. Bell. So in other words, Roe against Wade, one of the more popular decisions in some quarters and unpopular in other quarters, cited Buck v. Bell approvingly. Right? Cited Buck v. Bell approvingly. And once in a while, Buck v. Bell still does get cited for one proposition or another. So this is still law, formally speaking. I don't know whether I'd want to go into the court and cite it with any enthusiasm, but other unpopular cases in recent years have been cited in front of the Supreme Court, and the Supreme Court has relied upon them as precedent, even when experts in the field thought those cases were so disreputable they couldn't possibly be relied upon. And I think what I want to just suggest is that one of the virtues of reading a case like this and engaging with it is to try and engage in an archaeology of where our conventional certainties come from. To try to map out the different byways and highways by which we come to think that X or Y is protected by the Constitution, that X or Y is morally correct, that X or Y is the right way to engage with the world, that something is an outrage. And I should be very clear that, like most people who read this case today, I read the case and experience it as a moral outrage, and no part of what I've said tonight is intended to undercut that moral instinct of repugnance that I imagine most people in the room, probably all, had upon first reading it. Nevertheless, I think there's something tremendously valuable about engaging in the kind of practice that we just engaged in collectively, in which we try to get down underneath our moral outrage. And if this worked for you, I hope there was at least one moment in the course of our evening where you thought to yourselves, wait a minute. Now that can't be right, but wait a minute. I mean, if there was, then you didn't waste the last hour and 45 minutes, and we didn't waste it. If not, at least there was excellent single malt whiskey. And I think that the method that people like Charles have perfected and that I follow in as a student, the method of what we call, with not full justification, but with some attempt at emulation, the Socratic method of legal study, if it has a purpose that would in any way, shape, or form be recognizable to Socrates, and that's a big if, but if it does and when it does, it is in creating the aphoretic moment where you look at the case and you think to yourself, wait a minute, I can't quite figure out why this is wrong. In this moment, it might just be an instant, I think it's right. So what I want to suggest is that having that feeling for just an instant, that something that's morally repugnant is actually right, is a valuable human undertaking and can serve to enrich our experience. Could not have done this quite literally without all of you. Thank you very, very, very much.
I just want to conclude, of course, by thanking you for this remarkable process and by apologizing for my unruly behavior in trying to somehow
apologize for being snippy in
uphold the
response.
kind of principles of democracy, of democratic representation in the moment of a Socratic interrogation. I apologize for that. But I do think that what is so important for those of us in the humanities is, the final statement you made, which is how the aphoretic moment has to be dealt with. That the aphoretic moment does not immediately allow us to progress to an end. It does not take us back to the origins. It is somehow a moment in between, a kind of interstitial moment of indecision, indignation. We're against ourselves in a moment. And that, I think, is really the most important issue here. That the moment when we find ourselves divided and split, as an aporia produces, that's the moment where we understand alterity. The moment of alterity is not some otherness out there. The moment of alterity is the imbalance, the asymmetry, the tension, the tearing that you experience within the two things you hold dear or the two things you believe. And in that case, then, I think what this teaches us very much in the humanities is how the logical, the affective, the instrumental, and the ethical come together, both in the legal and aesthetic spheres. Thank you very much.
Thank you.